A federal judge in New York is standing up to Donald Trump's corrupt DOJ's request to dismiss without prejudice the criminal case that's been going on for some time now against the corrupt New York mayor, Eric Adams. If you've been following the MeidasTouch network, you know about the corrupt backroom deal made between the Trump DOJ, Pam Bondi, Emil Bove, who were leading that, along with Mayor Eric Adams and Eric Adams' lawyer, where it seemed to be, based on all indications of all of the people who resigned from the Southern District of New York afterwards and the people who resigned from the main justice in Washington, D.C., that there was this quid pro quo, either express or implied. Hey, Mayor Eric Adams, we'll dismiss this case against you despite copious, ample evidence of criminal conduct, but we scratch your back. You gotta aid and abet the criminal conduct and mischief and agenda and or other stuff that Donald Trump wants you to do. You have to say whatever Donald Trump wants. And then Mayor Eric Adams went on TV. He went on Fox with the quote unquote border czar in the Trump administration, Tom Homan, and they were like bragging about the deal. Then they were asked about them bragging about the deal. They were like, we're just cops, man. That's what cops do. We were joking. We didn't really mean it. It made a lot of lawyers very uncomfortable, prosecutors very uncomfortable who resigned. But when you have a grand jury that issues an indictment, and when the case then goes to a federal judge post-indictment who oversees a criminal case, you can't just say, hey, we're just dismissing this case. You have to have some reasoning. The law still applies. Now, normally this type of quid pro quo would be totally unheard of. Prosecutors would exercise their prosecutorial discretion, have good faith grounds why they would dismiss a case in the first place, and usually without event, a judge dismisses the case. But right now, this federal judge in New York, especially with all of the resignations, the fact that nobody in the prosecutor's office in New York wanted to file this document, and it took someone to reluctantly file it in Washington, D.C., the judge says, no, I'm not just going to agree to dismiss this case. The judge then went on to describe the case law here, how a judge has to evaluate the circumstances surrounding a dismissal like this and determine if it is in the interest of justice. Now, Harry, I guess the first question I want to ask you is, have you ever heard of anything like this in your time as a federal prosecutor, both as the top federal prosecutor in the Western District of Pennsylvania, and then also working as a top federal prosecutor, fourth floor leader in the Department of Justice? So have you ever even heard of a situation where like this goes down? And then maybe just flesh this out for our audience, what's happening here, what the judge did.
Okay, so a Rule 48 motion, which says, I know we brought this case in front of you, Judge, but please dismiss it. That I've heard of. Things like that happen, but they happen, and this is just axiomatic in the Department of Justice, because something is developed with the facts or the law. And the thing that has made this so notorious and forced the resignations of so many prosecutors is that this case, the acting deputy attorney general, who was issuing the orders in very sort of overbearing fashion, said, yeah, there's no problem with the law. Yeah, there's no problem with the facts. But, for example, as you were just saying, Ben, we want Adams to play ball on immigration and scratch our back. That's like so elementary a reason that you cannot dismiss a case, that you do politics without fear or favor. That would, I mean, you do prosecution and law enforcement without fear or favor. And that's obviously would be doing it with favor, with cutting him a break for that reason. That's what made the huge crisis within the department. Bove, the acting deputy attorney general, had it out in black and white, and that's what made the acting U.S. attorney in New York and the head prosecutor on the case and 3 different prosecutors back at Main Justice all saying, we cannot do this. So now back to the judge, however, because what I haven't heard of, and I think I've read about it now, but it's very, very tricky. Could a judge say, guess what? I don't accept this dismissal. It's not in the interest of justice, I find. And therefore, it needs to go ahead. Now, at that point, the Department of Justice will say, well, we're not going to do it. There is some allowance in the law for a judge to appoint a prosecutor from say, the bar to do it. Ain't going to happen here, I think, Ben. It's just too funky, too precarious up on appeal. However, the searching inquiry that you described to figure out, is this in the interest of justice, that can happen, and it already had commenced. The bad guy here, the acting deputy attorney general, showed up for a hearing a couple days ago in Judge Ho's court. They went through a few things. The judge took it under submission, and then actually a group of former U.S. attorneys filed a motion saying, you haven't heard the arguments against dismissal. Adams and the DOJ, they're saying the same thing to you. You really, for this process to determine if it's in the interest of justice, should hear from someone else. And that's why today, Judge Ho appointed this guy, Paul Clement. Now, Clement is quite the high-profile, famous lawyer. He was the former Solicitor General. He was a Supreme Court clerk. He's a really tippy top of Mount Olympus Supreme Court advocate. I've litigated against him, known him for years. He is the real McCoy. And if he took this appointment, you can bet that he is going to zealously discharge his mission to Judge Ho and give him the best arguments for, you know what, this isn't in the interest of justice. And those arguments could well involve the development of further evidence, the kinds of things that Beauvais said, or what happened in that room when he shut him in, like school children, and said somebody is going to have to decide to file the motion. All of that has real potential for embarrassment, and just to me, it's been so important because it shows in this war of words about weaponization who's been lying, who's been telling the truth. Weaponization is when you do things and you don't have the facts of the law on your side. Otherwise, it's prosecution. And then it's the Trump forces who are clearly pro-weaponization here. And the previous prosecution, say, of Donald Trump, that weren't. So what I think we can look to Ho to do with the advice and advocacy of Paul Clement is really to develop what is not just funky, but irregular, nasty, over-the-top, unethical about the total strong-arming tactics by the acting deputy attorney general, and maybe we'll find out it goes higher. And then I think, however, and that part may be a little tough. There may be some pulling of teeth, and Beauvais may say, no, I'm not going to tell you that. And then where are we? Nevertheless, I think the record will be developed. I think we'll see what some of the things that went awry here. And then at the end of the day, having done that, I think you will see Judge Ho maybe give him a scolding, maybe do an opinion that really lays out findings of fact and make clear that this has been really improper, but then says, okay, you want the dismissal, I'll give you the dismissal. But that's, I think, the import of Clement being there. We're going to really develop the other side of things, and definitely in terms of argument, and I hope also in terms of evidence.
You know what I'd like to see, and I guess, this is the law professor version in me. I like to think about tolling doctrines, in class actions. Mm-hmm. Sometimes there's a doctrine called American pipe tolling while a class action is pending.
You are a professor type.
Individual case claims are pending and trailed so that they're not waiving the statute of limitations, pending the resolution of a class action. And just so people know, tolling means it freezes the statute of limitations, for a period of time. My concern here is that if the statute of limitations, runs out on any of these claims with the dismissal without prejudice, could it be brought again by a future administration? And what does that look like? And, to me, I wonder if an outcome, and again, I don't know, again, if I'm being too professorial here and in practical world, this couldn't happen, but that there is some sort of equitable or judicial tolling, even if it's dismissed, to allow future Department of Justices to revisit it, and that statute of limitations are not run while this period of very questionable ethics is or outright criminality is before us. So if now's the time for those type of doctrines to emerge, I welcome them. But I don't know what you think about that, or if that's just some dorky professorial side.
No, not the Professor Meidas, please. But this is like a classic braiding of law and politics. And Adams is in a whole world of hurt because he came out, as you said, on TV and basically said, I'm going to play ball with the Trump administration. What does that mean? I'm not going to do what my constituents elected me to do by furthering our own immigration policy. So he's now in all kinds of trouble. His 3 deputies quit on him. One news flash to report. There was some thinking that maybe the governor would exercise her powers, which she has, but they've never been used in history, to remove him. And by the way, since the DOJ was saying, and they said it again in open court, yeah, we might bring these charges again. Once he's of no use to them, it would be, very in character for them to, put him back in the hot seat. Anyway, today, to not a lot of people's surprise who are familiar with New York politics, the governor of New York, Kathy Hochul, made it clear she's not going to try to remove Eric Adams. So he's in this political tight spot, but that gave him, between the rock and the hard place he's in, the hard place eased up a teeny bit because he's not going to be yanked by her. On the other hand, if he really does, as he suggested he will on Fox and Friends, play ball with the Trump administration, that means, let him run roughshod and go get immigrants and the sorts of things that New York doesn't want him to do. It's going to be a major political scandal. So either way, the squeeze is on him big time.
There it is. Harry Litman, Talking Feds YouTube, Talking Feds Substack, and the Talking Feds podcast. Make sure you all subscribe to all 3. It's where I get my legal news from. Talking Feds Substack, Talking Feds podcast, Talking Feds YouTube. Subscribe now. Harry Litman, thanks for breaking that down.
Hey, thanks, Ben.
Can't get enough Meidas? Check out the Meidas Plus Substack for ad-free articles, reports, podcasts, daily recaps from Ron Filipkowski, and more. Sign up for free now at MeidasPlus.com.